What on earth is going on around the world? 우리가 평화롭게 사는 세상 안과 밖에서는 어떤 일들이 일어나고 있는지 여러분 혹시 아시나요? 그래서 모셨습니다. That's why we have our one and only lawyer here in the studio here on 사건File. 오늘은 허수연 변호사님 다시 스튜디오에 모셨습니다. 안녕하세요.
안녕하세요.
왜 이렇게 소심하게 인사를 하십니까?
네.
Well, good to have you back. It's already been 3 weeks. 벌써 3주가 지났는데요. 어떻게 지내셨어요?
잘 지냈습니다. 시간이 어떻게 가는지 몰랐어요.
Yeah, especially. 그동안 뭐 어떤 케이스에 뭐 집중해가지고 굉장히 바쁘시게 지냈을 텐데.
네, 여러 가지로.
여러 가지.
네, 있습니다.
이런 confidential 같은 거 있죠?
네, 있습니다.
You can't talk about certain things. What can you say?
I can't talk about the exact names of the clients
I see.
or any specifics of any case. So I'll just
Zip your mouth.
Yes.
For everyone's sake, I guess. But today, we are here talking about a particular subject. I guess it's a continuation of last week as well. 저번 주에도 의료에 관련된 그런 사건들이 굉장히 많았는데 충격적인 게 또 굉장히 많았고 해가지고 이번 주랑 연관이 있을 텐데 오늘은 어떤 주제일까요?
네. 오늘 들려드릴 이야기는요. 일단 사기 사건부터 시작하는데요. 의료와 관련된 사기 사건이라서 저번 주랑도 연관이 있을 듯합니다. 먼저 사건의 내용부터 들으시겠습니다.
Alright, 함께 들어보죠.
의사면허증을 위조해 30년 가까이 의료행위를 함으로써 공문서 위조, 위조 공문서 행사, 사기 등 혐의로 구속 기소된 60대 A씨에게 징역 7년 및 벌금 500만 원이 선고됐다. 판사는 피고인의 무면허 의료행위로 의료질서를 문란하게 했으며 보건안전에 심각한 악영향을 저질러 엄히 처벌함이 마땅하다라며 피고인은 검찰 수사가 개시돼 조사받았음에도 무면허 의료행위를 계속했다고 판시했다. 이어 피고인의 진료를 받은 환자가 1만 5천 명에 달하며 피고인의 진료는 심각한 의료사고가 발생하는 분야가 아니어서 실제 의료사고가 발생했더라도 환자들이 이를 몰랐을 가능성도 배제할 수 없다며 병원을 속여 5억 원을 초과하는 고액 급여를 받은 점 등을 감안했다고 양형 이유를 밝혔다. A씨를 채용한 병원장 7명에 대해선 피고인의 의사면허증 유효 확인 절차를 거치지 않았다라면서도 피고인에게 기만당한 점이 크다며 벌금 500만에서 1천만 원을 선고유예했다. 다만 병원장 B씨에 대해선 과거 무면허 직원에게 수술을 보조하도록 하는 등 의료법 위반 전력이 있는 점을 고려했다며 벌금 2천만 원을 선고했다. A씨는 공소시효가 남은 2014년 10월부터 지난해 12월까지 의사면허증을 위조한 뒤 병원에 제출해 의료인 행세를 한 혐의로 기소됐다. 그는 의사면허증을 취득하지 않고 1993년 의대를 졸업한 뒤 1995년부터 전국에 있는 병원 60곳에서 근무하며 의료행위를 한 것으로 조사됐다. A씨가 실제로 의대에 재학했기 때문에 그를 고용했던 병원장들은 A씨가 내민 위조 의사면허증을 의심하지 않았던 것으로 전해졌다. 그는 주로 미등록 고용이사 형태로 단기 채용돼 병원장 명의의 전자의무기록 코드를 부여받아 병원장 명의로 진료하고 처방전을 발행하기도 한 것으로 드러났다.
Wow, an interesting case. It's certainly incredible to learn about how these people can forge their license for so long. But 한번 영어로 한번 요약하겠습니다. Let's take a look at the translation. So there's a guy by the name of Mr. A has been sentenced to 7 years of imprisonment and fined with 5 million Korean won for forging a medical license and practicing medicine without a license for almost 30 years. 꼬리가 길어도 너무 길었네요. 그죠? Well, it was noted that although the defendant treated over 15,000 patients, they may have been medical accidents unknown to the patients due to the nature of the medical field. So the sentencing rationale considered the defendant's deception of the hospital receiving compensation exceeding 500 million Korean won. 7 hospital directors who hired Mr. A were also suspended and faced with a fine ranging from 5 million won to 10 million Korean won as they were deceived by the defendant. However, one of the hospital directors, Mr. B, was fined 20 million won due to his involvement in violating the Medical Service Act of Korea in the past. Now, Mr. A was indicted for using a forged medical license from October 2014 to December of last year. An investigation revealed that he graduated from medical school in 1993 but did not actually obtain a valid medical license. He worked at 60 hospitals nationwide starting from 1995, mainly as an unregistered employed physician, using the names of the hospital directors for medical treatments and prescriptions. Well, it's a bit of a scary thought to think that, these people go under, a certain facade and will trick hospitals and even their coworkers into thinking that they are legitimate in working as a medical physician. But let's take a look at some details, and I want to ask a few questions. It wasn't that easy. 쉽지 않을 텐데, 그죠? It can't be so easy. 의사 면허증, 그리고 위조가 가짜를 이렇게 오랫동안 알아차리지 못할 만큼 그렇게 쉬운가요? I mean, 어려울 것 같은데 어떻게 생각하세요? How does that work?
I believe that it won't be easy. As far as I know, medical practitioners with valid licenses are granted certain unique numbers that authenticate and validate that specific individual.
Right.
So in Korea, there's also a website where people can freely have access to, which is 보건복지부 면허 안내. So anyone can just go on the website and
look it up. Wow.
And I really have no idea how Mr. A managed to forge a medical license and practice medicine without it for almost 30 years.
Right.
So I believe he was just hiding under the shadows of other people, not attracting any attention.
Yeah, I mean, he's got to be able to, be quick on his feet as well. Have you ever seen 그 Catch Me If You Can 영화, 리오나르도 디카프리오 나온 영화 같은 그런 스토리인 것 같은데요. 때로는 이런 영화를 보면 재미있을 텐데 실제로 뉴스에 보니까 어머 어떡해. It's so scary, and especially because it's dealing with people's health. It could be very harmful, but wanted to take a look at actually what is medical practice. 의료 행위를 했다라고 하는 것은 어떤 거를 말하는 걸까요?
그 대한민국 의료법에 따르면 의료 행위는 의료인이 하는 의료, 조산, 간호로 정의가 됩니다.
Okay.
네. 그래서 그 의료법의 27조를 살펴보면요. 그 무면허 의료행위 등 금지라는 조항이 있는데 의료인이 아니면 누구든지 의료행위를 할 수 없으며 의료인도 면허된 것 이외의 의료행위를 할 수 없다고 정의가 되어 있습니다.
Okay.
근데 또 그 예외 사항으로 3가지가 있는데 첫 번째가 그 외국의 면허를 가진 자, 그리고 두 번째가 그런 의료봉사나 연구 이런 것을 위해서 의료행위를 하는 자, 그리고 마지막으로는 그 의학이나 간호학 같은 것을 전공한 학생인데 in our case, Mr. A was none of those exempted persons who were legally allowed to perform a medical practice in Korea. And also, it's obvious that the 7 hospital directors who hired Mr. A were held jointly and severally liable for encouraging Mr. A to commit the crime of engaging in an unlicensed medical practice.
Oh, is that what they did? They did in aiding him and encouraging him.
Yes, even though they didn't have knowledge of
I see.
his...
Could this be seen as negligence as well?
Yes.
From the employer point of view?
So the hospital would also be liable as a separate entity.
Oh, wow. Yes. So that's, it said that he was involved with 60 hospitals throughout 30 years. Then do 60 hospitals have to pay the certain fine since they were involved in, in any capability?
Yes. After the court comes to a judgment, then they will have to either be liable jointly, so they'll have to divide up the
Oh,
damages.
I see.
Share the damages and pay their portion.
Okay. So if it's, let's say, 10,000 or 10 million won, it's not each hospital pays 10 million won.
It depends on the specific
Okay.
penalty that the court issues.
I see. We talked about this before briefly last week. How it seems like Korea has a weak sentencing, and it seems like if you're going to trick people in doing countless medical practices for 30 years. 500만 원 벌금이 조금 약해 보일 수 있을 것 같은데요.
네, I agree.
Yeah, how does that come up to be only 5 million won? 7 years we found that was almost like the max, the cap
True.
of how many years people can be in prison. Is this also the max as well, 5 million won?
I had a look at the Medical Service Act of Korea briefly, and the penalties mentioned in the act was quite low compared to those in the US. And also, although the judges in Korea, they have their discretion to, decide on the exact penalty per each case, they tend to be quite gentle when it comes to,
The actual sentencing.
actual sentencing.
Interesting. I mean, are we talking about like the judgment as well? There's quite a few terms here. 막 판시가 있고요. 뭐 판결, 판단 등이 있는데, what's the difference between, 판시? How is it different from 판결 and 판단?
They sound the same.
They do.
And they sound the same. The three words basically mean the court's final judgment
Okay.
or the jury's verdict.
Okay.
And generally speaking, 판시 is when the court makes a ruling with supporting reasonings with regards to a case on hand. And 판결 is when the court makes a ruling and executes a sentence imposed on a guilty person. And 판단 is a broader term that encompasses both 판시 and 판결. So 판결 is more like the sentencing, so the penalty issued to a person. And 판시 is more of the reasoning, the judgment, the underlying reasoning behind a judgment.
저만 그런가요? explanation 들어도 그런가요?
They're similar in concept.
근데 속으로는 뭐지? But okay, it's interesting to know that they're all different. 판시 is a ruling on a particular case rather than of the person. Is that right? And 판결 is for the sentence on the person?
That's tricky. They sort of mean the final judgment, either on the person or on the whole case.
Okay. 사전에 우리 GPD님의 사전을 보니까 어떤 판사 같은 경우에는 어떤 상황에 관하여 판결하여 보임. 판시는 어떤 사항에 관하여 판결하여 보임이라고 하는데요. 맞나요?
So they're the same.
They're the same. All right, well, it's good to know. It's interchangeable. I guess you can use them in the same situation. So let's take a look at fabrication. 한글로는 공문서 위조가 나오는데요. So that's the fabrication of, an official document. But, 뭐 위조 공문 서행사라고도 하는데 이건 또 뭔가요?
그래서 공문서 위조가 형법에 정의되어 있는데요. 제225조에 공문서 등의 위조와 변조에 대한 조항이 있습니다. 그래서 공문서 같은 경우에는 public document라고 생각하시면 되고,
Okay.
그 행사할 목적으로 공무원이나 그런 공식적인 문서를 위조하거나 변조한 자는 뭐 징역에 처한다 이런 내용인데, 여기서 행사하는 거는 행사 is commonly known as exercising.
Okay.
So exercising power or exerting power.
네.
But in this context, 행사 is the uttering of falsified official document. So in legal terms, uttering is basically a crime that involves the act of passing or using a forged document, like a forged check.
Right.
So it's when you intentionally create a forged document, here being the medical license or financial instrument, and circulating it into the public.
I see. And circulating into the public. So, a few, I don't even want to say years ago, maybe around last year or during COVID, 팬데믹 중에도 그런 뭐 PCR 검사에 확인하는 그런 증빙 같은 거 있잖아요. Like in the States as well, I don't know more so in Korea, but you would have to have a particular identification card or some sort of certificate that said you got all 3 or all 2, you know, what do you call that? Vaccinations.
Yes.
그런 것도 uttering이라고 할 수 있나요? People would forge these and,
Yes.
and they'd pass them around.
Yes, exactly.
Aha.
Yes, that would be uttering.
So how would you, I mean, it's hard in those situations. How would you, you know, catch the criminal, you know, if it's something that's spread so widely compared to this particular case, it's just one person. Would those be 2 very different cases?
I wouldn't say they're 2 different cases. You just have to find the starting point, the root of all the things that cause the event.
Yeah, I think in different cultures, in different countries, we have our own things that we would forge. Like in the US, for example, 미국에서는 21살이어야 돼야 이제 술을 마시기 때문에 there's a lot of 뭐 you know, 고등학생들이 they would forge their, you know,
ID.
driver's license or ID just to get, you know, a drink or so.
Yes.
그런 것도 it's uttering.
Yes, that's uttering.
Okay.
Yes.
Would those be 더 약하거나 더 강한 sentence를 받나요?
If the accused is a student, if he or she is under 18 years old, then the law would be lenient to those.
미성년자.
네, 미성년자.
As a minor.
Yes, as a minor.
Interesting.
Yes.
Yeah. Well, there's still lots to learn about a very interesting story regarding Mr. A, who forged his license, engaged in medical practice for almost 30 years. Let us know if you have any questions regarding this case. In the meantime, let's take a listen to a quick song. 노래 듣고 다시 오겠습니다. Here is BTS, Fake Love. It's all fake. 다 가짜이지 않을 텐데. It's hard to trust people, right? Especially these days when there's so many 사기s, a lot of scams, a lot of frauds. But how can we actually define 사기 in a lawful term?
Okay, so fraud is a broad concept. So under the Criminal Act, 형법, Article 347 defines fraud as an act of defrauding another person, thereby taking property or obtaining pecuniary advantage from another. So it includes 전세 사기 in Korea, and forgery of a document, identity theft, and all kinds of financial fraud as well.
요즘 전세 사기 같은 게 it's quite rampant these days. And so for that reason, there are these, you know, websites. Like you said, you can check people's identity card or authentication numbers and things like that. 전세도 어떤 매물에 대해서 다 알아볼 수 있는 그런 사이트도 있잖아요.
네, land register 같은 deed 볼 수 있는.
Right. So would because you made those things open and available for the public, does that mean the public also has somewhat of a responsibility? Are they negligent by not, you know, checking these information out and more?
In my opinion, I think even after properly checking the land register, you can't really decide because almost every single property has a, what is it, like 담보? 대출,
right,
융자.
Loans.
Yeah, loans.
Right.
Mortgage.
Sure.
On every piece of land.
Right.
Almost every piece of land. So even though you check properly, like where you get the 전세, you can't really, you know, choose a property that does not have a 융자 on
Right,
it. So
right.
I don't think you can hold that person liable, that tenant liable
I see.
for
Not knowing. Right. Why do you think do you think there is a particular reason why these 전세 scams are on the rise? Is it like an easy scam? Is it easy to, you know, lie to people, deceive people about, you know, the credentials of their homes, the mortgages on their properties?
I think because almost 3 to 5 years ago, it was the loan system. So the banks would give you like loans easily compared to like this year.
Right.
So people would, you know, loan a lot from the bank and use that money to buy many pieces of property,
Right.
invest in them, so that for the purpose of making money. And because nowadays the interest rates are high, those people, although they didn't have the intention in the first place to defraud people, now because their situations become so difficult,
Right.
they just become,
I see. They're trying to find loopholes, trying to
Loopholes,
find ways
yes,
to, pay their interest that is super high.
Yes.
When back then it was very low,
Yes.
able to, obtain a lot of money and, spread it out in multiple investments. But now it's high and they can't afford it themselves.
they can't afford it, so they can't really, pay the money back to the tenants.
Right. They
So-
put themselves in the trap.
True.
There you go. Spread yourself out too thin. Well, I mean, this isn't the first time we're hearing about this. And it's interesting because 기사가 나온 건 이거 하나뿐이겠지만 there must be so many other cases that are quite similar to this. 그죠? 비슷한 케이스 소개해 줄 수 있나요?
Actually, I did some research, and I was actually surprised to find that there have been a lot of cases. So there was one case where a man faked an attorney license in 2011 to get into a law firm.
성공했어요?
I didn't read the conclusion, but I think he attempted, but then he failed.
대범하네요.
Yes, that happened in Korea. So I was really surprised to find that.
Very bold.
Yes, and there was another case where various accountants, not accountants, various people,
CPA 같은 분들이요?
they faked their CPA licenses and used the forged license to, loan like 30억 from the banks. Wow. And then they because the credibility, the credit level is high, the banks are more, lenient when they,
lend
give
money
loans.
out.
Yes.
Wow, that's really interesting. I mean, 이런 것도 사실 영어로 보면 약간 와, it's very 이것도 재능인가? 라고 생각할 수 있잖아요. 왜냐면
맞아요.
you have to be really smart to be able to be a criminal because you got to think of all of these different loopholes, different ways. 이것도 공부를 해야 되는 건데. 이왕이 공부하는 건 why don't you just, do the real thing? Because it seems like there's as much work involved into, forging a license as to actually obtaining the license. But that's interesting. Then can we get to know 변호사 이제 like 면접 시험 같은 거를 보면은 what do they ask you or, what does it take to be a lawyer? This is personal question.
It's a personal question. I don't remember, frankly, but I think.
Do you think it's something that's easy for people to, get into without having like a degree or a license? Or...
They don't ask you about the specific law. They might.
Oh, okay.
But they just want to know about your background, like what you have been doing in your life.
그래요?
네, for me, it was like that.
그러면 이 사람이 어떤 사람인가?
네, like personality, how you've lived your life, basically.
Interesting.
But then they ask you like if you have written any like.
Yeah, interesting things.
Yes.
Well, in any case, we'll have to get to know your story a little bit sooner, but we're running out of time. Stick around, there's still much more to come. To be continued. What on earth is happening around the world? 우리가 평화롭게 사는 세상 안과 밖에서는 어떤 일들이 일어나고 있는지 여러분 아시나요? That's why we have our one and only lawyer here in the studio on 사건File. 이번에는 we're going to be talking about a very interesting, very 막장 드라마 같은 그런 주제인데요. 변호사님, 어떤 주제일까요?
네, 다음은 사기가 아닌 드라마를 보면 나오는 단골 주제죠. 불륜인데요. 불륜을 당해 화가 난 당사자가 오히려 역으로 고소당한 사건입니다. 이 사건은 어떻게 결과가 나오는지 한번 보시죠.
오케이, 함께 들어보죠.
A씨는 2021년 10월 24일 오전 10시부터 4시간가량 남편과 불륜 관계인 B씨가 운영하는 경남의 한 가게 근처에서 불륜을 하지 맙시다라는 내용이 적힌 피켓을 들고 1인 시위를 벌였다. 이날 시위로 인해 A씨는 명예훼손 및 업무방해 혐의로 기소됐다. 하지만 재판부의 판단은 달랐다. 재판부는 피켓에는 불륜의 대상자가 B씨임을 추측할 수 있는 어떠한 문구도 기재돼 있지 않았다며 B씨가 있는 건물에는 B씨 이외에도 다수의 사람이 상주하고 있는 것으로 보인다고 밝혔다. 이어 피켓을 들었다는 것만으로 명예의 주체가 특정됐거나 B씨의 사회적 가치나 평가를 저하할 만한 구체적 사실을 드러냈다는 점도 증명되지 않았다고 덧붙였다. 피켓 내용만으로 불륜 당사자를 B씨로 특정하기 어렵다는 것이다. 업무방해 혐의도 성립되지 않는다고 봤다. 재판부는 A씨는 가게 출입문에서 다소 떨어져 있는 거리에서 피켓을 들고 앉아 있었을 뿐 출입객의 통행을 방해하는 행동을 하지 않았다며 1인 시위를 벌인 것만으로 영업장 운영을 방해할 정도의 위력이 행사됐다고 단정하기 어렵다고 언급했다. A씨가 남편과 B씨의 대화 내용을 무단으로 녹음한 통신비밀보호법 위반 혐의에 대해서는 선고를 유예했다. A씨는 2021년 10월 부산의 한 사무실에 소형 녹음기를 몰래 설치해 남편과 B씨의 대화 내용을 무단 녹음했다. 이후 남편을 피고로 하는 손해배상 청구 소송에서 무단 녹음한 대화 내용을 증거 자료로 제출했다. 또 내연녀 B씨를 상대로 남편과의 불륜 사실을 인정하는 각서를 쓰라고 요구하는 과정에서 시비가 붙어 상해를 가하기도 했다. 판사는 상해 혐의에 대해서도 선고를 유예했다. 재판부는 이 사건 분쟁의 발단, 귀책 사유가 누구에게 있는지를 떠나서 A씨가 B씨에게 상해를 가했고 위법하게 녹음한 내용을 소송의 증거자료로 제출한 점에서 죄책이 가볍지는 않다고 말했다. 다만 배우자와 B씨 사이에 부정행위 사실을 항의하던 과정에서 범행에 이르게 된 점, 미성년 자녀를 양육하고 있는 점 등을 유리한 정상으로 참작한다고 양형 이유를 밝혔다.
이거는 It's like 애 끄는 그런 스토리인 것 같은데요. Oh my goodness. First of all, I do want to ask, because there are places around the world where 불륜 is illegal, 한국도 그렇지 않았나요? In the past? Or was it ever illegal to have an affair or anything like that? 그런 법 있었나요? 없었어요?
I actually think the law changed 2 or 3 years ago.
Oh, really?
Yes.
Oh, it used to be 불법.
Yeah,
네.
it used to be, but then it became not 불법.
그러면 합법이라고 하면 it sounds so weird.
So weird.
불륜 합법. It's just so. It's now legal to have an affair. Okay, well, let's take a look at the English translation. 영어로 요약 설명해드리겠습니다. So, Miss A conducted a one-person protest holding a picket sign with the message, "Let's not cheat and commit adultery," near a store of B, who's in an affair with her husband, for approximately 4 hours starting from 10 a.m. on October 24th, 2021. As a result, A was charged with defamation and obstruction of business. However, the court ruled that the picket did not explicitly identify any specific individual as the target and that the building where B was located had multiple occupants, leading to the conclusion that the defamation charge was not substantiated. Regarding the obstruction of business charge, the court determined that A did not impede the passage of visitors and that the act of a one-person protest did not significantly disrupt the operation of the establishment. However, A did receive a suspended sentence for unauthorized recording of conversations between the husband and Miss B, and even assault charges. The court acknowledged the seriousness of A's action, but also considered Miss A's objections to the illicit behavior between the spouse and B and the fact that A is raising a child that is under the age of 18 when determining the sentence as well. Well, it's certainly a heartbreaking story if you're involved, but from the outside, it seems like you just want to grab some popcorn and look at the drama from afar, right?
Yes.
I mean, we talked about quite a few things here. I mean, we talked about, recording people's conversations and how it is illegal unless you are part of the conversation, if I remember correctly. And also I want to talk about stalking as well. We talked briefly about stalking a couple weeks ago. Would this be considered stalking?
If I don't know the exact legal definition for stalking in Korea, but if Miss A followed A.
If Miss A followed B.
If A followed
Right,
Miss B,
right.
then that would be
considered stalking.
considered stalking.
Yeah, okay. But we're talking about like defamation here, right? Even though there was no specific name, 뭐 A씨가 B씨 나와라! 막 그런 이름도 없었잖아요.
네, 맞아요.
So how can we call that defamation? In Korean, it's what? 명예훼손이라고
Yes.
하잖아요.
네, 명예훼손.
So what's the legal definition of defamation?
네, 한국 그 형법 307조에 명예훼손이 정의되어 있는데요. 명예훼손은 공연히 사실을 적시하여 사람의 명예를 훼손하는 자는 2년 이하의 징역이나 금고 또는 500만 원 이하의 벌금에 처한다라고 규정되어 있습니다. So the Korean courts have ruled in various case laws that any crimes of defamation are established only if a statement damages the reputation of the person making the complaint. So in our case, the court reasoned that because the picket didn't identify or pinpoint B as the person who committed the cheating and adultery, B's reputation was not harmed for the crime to be established. So there was a similar case where the Supreme Court of Korea ruled that gossiping about a stranger in the office alone with a friend does not constitute a crime of defamation.
Okay.
And this was because the possibility of spreading, which is a component of defamation, was not established. And also, to contrast that with another case, there was another case where a person posted an article online for the purpose of slandering another person.
그죠.
And deleted the article after 5 minutes, and defamation was found, even though the article was deleted only after 5 minutes.
아, 삭제해도 5분 후에 삭제해도
네.
it's considered defamation.
Defamation.
Here's a question. Even if it's not true, defamation인가요?
네. It doesn't matter if the information is correct or false.
사실이어도 사실이 아니어도
아니어도, 네.
If
If it's
it's-
targeted to a person and that harms that person's reputation, then defamation is established.
연예인 같은 경우에는 어떻게
네.
되나요?
It's easier to establish because a public figure, you can specify that person and attack them. So many people actually, many celebrities, I saw many articles where they claimed defamation against people.
A particular netizen or things like that. Because it is true. I think more so in Korea, I would say that, you know, people are very vocal of their opinions.
Yes.
Of certain, you know, and you have the right to have these opinions, but it's just somehow it seems very harmful because, you know, they target, you know, not only the celebrity, but the celebrity's parents and all that kind of stuff. Yeah. So in that way as well, it is considered defamation.
Yes.
And even if it's in the, you know, school to school, for 미성년자 같은 경우에도, like in schools, there's a lot of bullying that happens, like cyberbullying. Is that the case as well?
I think so. Yes.
Yeah, we got to be careful. I mean, you know, not just because, you know, it's the law, but even more so because it is the law. The second part is obstruction of business, right? 업무 방해란 뭘까요? It's like 어디까지 업무인지도 모를 수도 있고, like how can you consider something an obstruction of business?
Okay, so 업무방해 is also defined under the criminal law of Korea. So under Article 314, any person who interferes with the business of another by the threat of force shall be punished by imprisonment or a fine. There is a blurry line between what is 업무 and what is not 업무, but the scope of business where an interference of business is established includes not only economic activities conducted during normal business hours, but also affairs involving mental efforts, which is 정신적인 사무, and also unpaid and non-profit affairs. So 무보수이거나 비영리적인 사무도 다 업무로 포함이 됩니다. But it's significant that if the business has an illegal motive or is engaged in an illegal activity like 불법 도박장을 영업한다거나 하면, then such business would not be able to claim for any protection for interference of business.
Okay, so if they themselves are working somewhat illegally, whether it be, working in a building that doesn't allow, businesses to be held,
exactly.
then you can't claim this case.
You can't claim this case.
Okay, good to know. Yeah, well, what is like mental efforts then?
I wasn't sure of that as well, but then I'm guessing it's similar to my work. Something that doesn't involve any physical activity, but like your mental activity.
Sure. So like if it's you working at home as well on certain cases.
Exactly. So it doesn't matter where you are.
Okay.
As long as it's not illegal.
Right. Yeah, okay. That is true. What about 위력? What does it mean by, 위력 being a 행사? We talked about 행사 before as well. 근데 뭐 위력이 행사됐다는 말.
네.
그런 의미는 뭘까요?
So 위력 is a threat of force in English, and exercise, 행사 is to exercise.
Right.
So 위력 행사 means a threat of force has been exerted or exercised on another person.
I mean, this is, are there more details as to if Miss A really did use more force or, physical threats to Miss B? 그런 게 있었나요?
So it can be a threat. So even if you're like in an immediate threat of force, so you become intimidated, then that would be 위력.
그쵸.
행사.
그냥 앞에 서 있는 게 그 자체가
yes,
it's
if
a
you
threat.
Yes, if you feel fear,
Sure.
intimidation, then
그렇죠.
that would be 위력.
Yeah. I mean, I don't know who to kind of, support here because I feel like it's not an issue of A versus B. 사실 남편이 잘못한 건데 why do we go to B? This is what we always say, even in America or everywhere in the world. 여자끼리 싸움이 아니거든요, 이게. It's really hard to hear about this and talk about this. Last week we talked about the lawyer's perspective taking on these cases. 이런 약간 emotional한 또는 traumatic한 이런 케이스를 받으면 기분이 어떠신가요?
I am not involved in those person-to-person
Right.
litigation, but if I did, I am an emotional person, so I would be, emotionally stricken every day.
Right.
Meeting those people,
Yeah.
mentally distressed people.
이것도 케이스가 한 3년, 5년까지 걸리는데 그만큼 you just have to pour out your emotions
Exactly.
and then set the line straight as well. 어디까지 바운더리를 둬야 되는지도
It's
굉장히 큰 일일 것 같은데. More talk about defamation and much more coming up, but we'll leave you guys with a quick song. 노래 듣고 다시 올게요. Still so much to talk about on this case of 불륜, infidelity. Always a fun topic. But in any case, here is 장기화와 얼굴들 풍문으로 들었어. Heard it through the grapevine. 풍문으로 들었어. An interesting song, especially as we are talking about an affair, infidelity, 불륜에 대한 케이스를 알아보고 있는데요. I mean, secrets, there are no secrets, but I guess it's illegal to record secrets as well. 이제 통신비밀보호법이란 어떤 법인지 궁금한데요. I think we talked about it briefly on a previous episode. But because Miss A, even though you feel for her, even though you think it's right for her to, know these facts, 그래도 불법이기 때문에 what is 통신비밀보호법?
Okay, 통신비밀보호법 is the Korean law on the protection of communications secrets.
Okay.
So under Article 3, no person shall censor any mail, wiretap any telecommunications, provide communication confirmation data, or record or listen to any conversation between others that is not made in public. So in our case, it's obvious that A was in violation of Article 3 for recording the conversation between A's husband and B in secret. So the point is that the conversation must have been made in secret, not in public.
Yeah. I mean, 불륜이기 때문에 비밀스럽게, you'd want to hide it from other people, which makes it even more of an illegal act because it's not legal to, I guess, record secret conversations, even though you are the girl that is being cheated on, which is so sad. But if we talk about recordings of other conversations, I mean, can it be used as evidence? You know, 증거가 되지 않는 건가요? Like 어디까지 합법이라 봐야 하고 어디까지 불법인 건가요?
As I'm a U.S. attorney, I know that under the evidence law in the U.S., any evidence that is illegally obtained or derived from unlawful searches or seizures are called fruits of a poisonous tree. And they're inadmissible at trial.
Cannot use them in trial.
You cannot use that in trial.
미국에서는 못 써요.
네, 못 써요.
Even if it's like 나 이 사람을 죽였다. 그 말 녹음했는데.
네, you can't use
You
it.
can't use it.
No, you can't use it in court.
Wow.
And I'm not sure what the law is in Korea, but if it's the same, then such recording would not be admissible in court because it was illegally obtained. It's possible that an evidence is admissible in court if such recordings were made in public because there was no reasonable expectation of privacy, which we discussed almost 3 weeks ago. And I actually found another interesting case where a court found a recording from a black box installed in a car that was admissible. So in this case, a black box installed in a car had a recording of husband B's affairs with 3 different women who were cheating with husband B.
Black box에 걸렸다니. Oh my.
And the black box had vivid recordings of husband B's voices saying, 여보 자기 애인 뽀뽀를 해주겠다 to those women.
어떡해.
And the woman argued that the black box recording was inadmissible in court because the recordings were obtained through illegal inspection. And the illegal wiretapping could not be, admitted as evidence. But the plaintiff wife A successfully argued that because the Korean 통신비밀보호법 only prohibits illegal wiretapping,
그치.
that a person intentionally records in real time, like on purpose,
그쵸.
the black box recordings which were recorded involuntarily and automatically without any intentional act to record were admissible as a legal evidence.
그쵸. 와, 이거는 성공적이네요.
네.
That's good to hear.
Yeah.
I mean, it's a fair argument, right? I mean, it does talk about the intentional versus the unintentional, and that's quite important in law, right? Whether it's intentional murder, unintentional murder, 이게 굉장히 중요하죠. But let's talk about like 상해. 상해는 또 어떤 거죠?
상해 is a crime of inflicting bodily injury on another. So under 형법 제257조, a person who inflicts a bodily injury upon another person shall be punished by imprisonment of over 7 years and a fine not exceeding 10 million won. And also, apart from 상해, there is 중상해, which is a serious version, aggravated bodily injury on another. And there is 특수상해, which is a special bodily injury by the threat of collective force. So of a force exerted by many people and also by carrying a dangerous weapon.
I see.
Yeah.
In this case, was the picket fence, the picket sign, a dangerous weapon?
It was not a dangerous weapon.
Can you argue that it is?
The other side could argue, but unlikely that the claim would be successful.
Yeah, interesting. I mean, it's interesting to see different parts of this case. I mean, especially because, this woman who you're rooting for, because she's the one who, 당사자이기 때문에 she's the victim in this case. And yet she's, being called as what we call it, the criminal, the perpetrator in this. And so she is sentenced, she has a sentence. But then again, the court is going lenient on her because she has kids. 그런 것도 생각하면서 센텐스 받나요?
Yes, the Korean courts, they do have leniency when they're dealing with parents with young kids, but compared to the U.S. courts, they tend to be less lenient when it comes to giving a sentence, because the Korean courts do take into account your specific situation, like your financial ability, disability, etc. But then the judges, they tend not to be lenient.
I see.
Yes. But in this case, the court considered that it would be more just to, be lenient, but
Yeah.
they tend not to be compared to the US.
I mean, this is, the guy's kid too, right? Husband, 남편의 또 자식이기 때문에 shouldn't that be considered as well? It's not just A's kid, it's also the husband's kid.
Sure.
They both share this kid. Well, in any case, 이제 최근 실리콘밸리 사상 최악의 사기극이라 불린 Elizabeth Holmes. This person who's called to be one of the biggest frauds in Silicon Valley's history sentence has been confirmed as well. But she wasn't even in prison because she had kids or she had infants, babies. And she can see her children every weekend and even breastfeed them in jail. 만약에 이 일리자베트 홈즈이 한국인이었다면, 한국에서 일어난 일이었다면 이런 모유도 줄 수 있다는 그런 leniency가 있었는데 한국은 이런 비슷한 법이 있나요? Or
As I mentioned before, I believe that the criminal system in Korea does not offer children or infants of a criminal with any special facilities or care systems. So I actually have read many articles saying that at times where when children need parental help the most, they are forced to separate from their criminal parents in Korea.
Right.
And the children are left to suffer from the social stigma of being a child of a criminal and from financial distress and mental instability. So I can say that the public welfare system in Korea does not give as much mercy as that in the US.
Right. I mean, it's sad to see and it's sad to hear about, but it's just a different culture and a different, criminal system and justice system and things like that. But in any case, 덕분에 많은 것을 배웠습니다. I had a lot to learn. 허 변호사님, 너무나 감사했습니다.
제가 더 감사합니다. I had fun.
Yeah, I had a lot of fun talking about medical malpractices, a lot of scams, 사기, 불륜까지 다 알아봤는데요. 3주 후에 또 어떤 이야기로 가져줄지 기대가 됩니다. In any case, we'll have to 마무리 here and we'll to see you in 3 weeks' time. 여기서 인사드리며 we'll have a great evening and we'll see you tomorrow. 여러분, 내일 봬요.